We're going to be talking about other legal developments as it affects derivatives and structured notes. And with that, I'm going to turn it over to Brad Berman. Great to see you again, Brad, as well as Brendan Young from Mayor Brown.
Okay, thanks, Keith. Yeah, this is Brad Berman. I'm counsel at Mayor Brown, and we have Brennan.
I'm Brendan Young. I'm in the tax group of Mayor Brown.
Yep. And we're just going to kind of sum up some recent legal developments. So, Melissa, if we could bring up the slide, change in definition of accredited. There we go. So, effective December 8th of this year, there are going to be some changes to the definition of AI and QUIB, and essentially these amendments expanded the types of individuals and entities that will qualify as such. Under the accredited investors, essentially we have some new categories of natural persons, licensed persons like your broker dealers who do Series 7, 62, and 82, regardless of their income or net worth. Also knowledgeable employees of funds for private placements by those funds. And also there are now spousal equivalents that are counted for purposes of income and net worth test and the knowledgeable employee test for joint purchases. There's also a number of new entities, including SEC and state registered investment advisors, limited liability companies, similar types of entities that have assets of excess of 5 million and weren't formed with the express purpose of acquiring the securities. And then any other entity that doesn't otherwise qualify as an AI, but meets the 5 million investments and asset under management under the 40 Act rules, and also certain family offices. And what they also did was they went to the QUIB definition, which obviously has to be institutions. So only the institutional parts of the QUIB definition were conformed to kind of meet up with the changes in AI institutions. So now these changes, let's see, I think next slide, Melissa. So these changes, how does it affect structured products? Well, we have, for example, our national banks that are subject to the OCC's Part 16 securities offering rules. And the typical rule they go under is Part 16.6, and that provides an exemption from registration with the OCC for offerings of non-convertible debt. It's limited to sales to accredited investors in 250,000 minimum denominations. Now, these offerings tend to be aimed solely at institutional accredited investors, but they now could include some additional categories of offerees. Next slide, Melissa. Another option for national banks is sometimes if 16.6 is considered too limited, maybe they want to get away from the 250,000 minimum denomination requirements, they can go under 16.7, which basically allows an exemption for offerings conducted in compliance with Reg D, no minimum denomination requirement. And these also tend to be directed to institutional accredited investors, but they might also include some AIs who are a natural person. In any event, the result of these rules is the pool of potential investors has been expanded. And of course, aside from national banks, for people doing Reg D private placements to AIs, there are now more potential offerees. Next slide, please. So let's go to our major topic now, and that's essentially the problem with LIBOR, what's going on with LIBOR. So, just to recap a little bit, LIBOR is no longer a robust transaction-based interest rate. LIBOR comes from submissions by what they call the panel banks. I think for US dollar LIBOR, there's 16 or 17 panel banks. There's a lot less actual transactions they're putting it. Most of it is kind of interpolation at this point, so it doesn't really have a good base anymore, and it's expected that it'll cease at the end of 2021. So what does this mean for, you've got tons of outstanding LIBOR floating rate notes, you've got preferred stock out there with a floating option. What's going to happen to them? Those securities their LIBOR mechanics are based on the 2006 ISDA definitions, and the fallbacks in there were not designed to cover a complete cessation of LIBOR. They were designed to cover brief cessation, maybe a day or so. And the problem is when you work, once LIBOR ceases and you work your way down through the fallbacks, you're going to end up with a fixed rate note because you'll keep reusing LIBOR at the last LIBOR fixing. So what have issuers done with this? Well, the first thing they did was they had this discretionary replacement option, and that was basically they're saying if LIBOR ceases, the issuer and the calculation agent will use an industry accepted replacement rate. That language kind of ruled until spring of 2019 when the ARRC came out with their recommended hardwired fallbacks when LIBOR ceases, and it falls back to SOFR, the secured overnight financing rate. Next slide, please. And the way this works, and I'm going to summarize because the fact is you shouldn't be, certainly banks and most other issuers really shouldn't be issuing LIBOR at this point. Although there still is a fair amount of LIBOR being issued, I'm hoping it's a very short maturity. Anyways, the hardwired fallbacks, they had 3 benchmark transition events where there were 2 permanent cessation triggers based on public statements or publications saying no more LIBOR. The third one, no longer representative, that's the infamous zombie LIBOR, because under the current rules, you could have 6 panel banks doing submissions. So that would be a really not robust rate and they could still publish. So anyways, then there's a replacement rate, kind of a waterfall you go through. And the first one's term SOFR, then compounded SOFR, governmental recommended rate, the ISDA fallback rate, and then back to a discretionary rate. And an issuer using these would have to make sure that they couldn't interpolate. In other words, if you have 3-month LIBOR note, they stop publishing 3-month LIBOR, but they publish 1 month and 6 month, you could kind of come up with 3 from that. And there's also spread adjustment alternatives, and it allows for various conforming changes and protects the issuer and the trustee. So let's go to slide 8, next one. So one of the things, as you'll note in that last slide, is the first choice was term SOFR. And the question is, where is term SOFR? Well, it's not here yet. There's ARRC just recently put out a request for proposals for the publication of forward-looking SOFR term rates. They're looking for an administrator to publish term SOFR. If there's sufficient liquidity in the SOFR derivatives markets, they might be ready in the first half of 2021. This is not a guarantee the term SOFR is going to actually be published. And the interesting thing is the ARRC for a long time was constantly saying we're not going to have term SOFR by the end of 2021 when LIBOR ceases. And so this is the first time they're kind of saying, well, maybe we will get term SOFR. So there's a little bit of hope there. Let's go to slide 9. The next slide, please, Melissa. So here is, as I said before, you really shouldn't be issuing LIBOR anymore. And that's because what the regulators are saying. In June 2019, and this was really almost just 3 or 4 weeks after ARRC came out with their fallbacks I just discussed, and they had a seminar down at NYU Stern Business School, which we went to, and we had Randall Quarles, Vice Chair for Supervision, Board of Governors of the Federal Reserve System, and he was saying you should be transitioning away from LIBOR. There's going to be a risk of value transfer even with the new fallbacks, and you're going to be questioned in hindsight. So he said the easier path is just to stop using LIBOR. So that was the OCC statement in 2019, very similar statement in September 2019 from the Federal Housing Finance Agency to Federal Home Loan Banks. By last March of this year, they shouldn't enter into any contracts with LIBOR maturing after December 31st of this year. Next slide. The OCC's in December 2019, the currency semi-annual risk report pointed out all the problems with LIBOR that, increased operational costs, compliance and reputational risks. That's kind of echoing what Coral said. They should seek to minimize expected pricing issues with observable objective rules determined prior to the LIBOR cessation. And the examiner is basically going to be asking questions of banks saying, how are you planning for this LIBOR transition? Next slide. I think you went one too far. Sorry. Go back one. All right, well, I will, I'm sorry, it's on the bottom of that slide, my mistake. December 23rd, 2019, the New York State Department of Financial Services sent a letter to New York banks noting that outstanding notes are going to become fixed rate notes, and they asked for New York State regulated banks to respond to the NYDFS explaining their plans. And finally, most recently, the FFIEC sent out a statement talking about risks from LIBOR instruments and that fallback language is insufficient. Okay, now let's go to the next slide. And this is a little timeline put out by the ARRC for floating rate notes. And you can see that if you were doing a LIBOR note by June 30th of this year, which is already passed, they wanted the ARRC fallbacks in there. Target for end of new use of USD LIBOR by December 31st, 2020. So there's your hard stop. They don't want you doing it anymore after this year. Now, the interesting thing is I mentioned before there was that discretionary fallback, which was kind of the first response, where they said we will use an industry accepted replacement rate. Now, they are saying that if you did that, you need to identify to your holder the expected rate and the spread adjustment by 6 months prior to reset after LIBOR's end. So let's imagine we have your typical 3-month resetting LIBOR note, and there's going to be a reset date on March 31st, 2022. By September 30th, 2021, you need to send a notice to the holders telling them what the new rate is and what the new spread adjustment methodology is going to be. Okay, so let's go to the next slide, slide 13. And so what has the ARRC, and I just want to mention that, by the way, the SEC is rate neutral. They specifically said they're not endorsing any particular rate. They just want people to have good disclosure. If LIBOR is causing risk, they're speaking to broker dealers and other bank registrants, but they said if LIBOR is creating a material risk, you need to disclose it. But they specifically said, we're not backing any particular rate. So, what has the ARRC been doing? What have they put out alternatives? Their favorite son is SOFR. So just to back up a little, differences between LIBOR and SOFR. Well, LIBOR, very familiar, first of all, forward-looking term rate. At the beginning of a 3-month interest period, the rate is set. You know what the rate is for the period. You know what the payments are going to be 3 months in advance, no problem. Now, SOFR is a backward-looking daily rate. And so how do you kind of cobble together an interest rate over a period, which there's a couple different ways to do it. We'll go through. But one of the issues is you're not going to know your interest payment until essentially the last day of the interest period because it's backward looking. So for example, if Friday is an interest payment date, the last day of the period would be Thursday. And consequently, you're not going to know until Thursday what you run your compounding formula and find out your rate and payment. Well, it's Thursday and you got to pay everybody Friday. So that's very little time to notify people and get the payment out. Okay, so how do you deal with this? How do you work in some advance notice? So ARRC came out with 3 model term sheets for compounded SOFR floaters. The first one was look back. And what this does is basically they're saying the daily SOFR rate for each day will be the rate for a certain number of US government business days before the date of determination. So for example, let's say an interest payment date was Friday, interest accruing through Thursday, and you have a 5 U.S. government securities business day look back in effect. So there, the last daily SOFR rate that was used for the determination of the compounded SOFR for that period would have occurred on the Thursday the week prior. So consequently, on that Friday interest payment date, the issuer, the paying agent, the holders, they've had a week's advance notice of the payment to be made on that Friday interest payment date. Next slide, please. Next slide. Good, thank you. Okay, so observation period shift. This is another one here. Basically, you shift the interest period back a certain number of U.S. government securities business days prior to the relevant interest payment date. Again, we have our Friday interest payment date, and the relevant interest period would be from and including the Wednesday prior to the previous interest payment date 3 months ago, but excluding the Wednesday prior to the relevant interest payment date. So if you have a 2 U.S. government securities business day shift, this allows 2 business days notice of the interest payment. And the last one, payment delay, as the name implies, this approach simply delays payment for 2 business days after the interest payment date, except at maturity or early redemption. So you have your typical interest period running from and including an interest payment date 2, but excluding the following one. Consequently, if an interest period ends on a Friday, holders will be paid their interest the following Tuesday. And for the final interest period prior to maturity or redemption, they used a lockout or rate cutoff, locking in the interest rate a couple days before, and that holds, and you get paid on the maturity, on the maturity or redemption date. Next slide, please. The next one, they came out with the SOFR index, and that was a model term sheet using the index measures SOFR compounded since April 2nd, 2018. That was the first date. What's nice about this is the compounding is built into the index. You don't have to run the fancy formula and the other term sheets. Simply pick 2 days in the index and compare them, and that's your rate. You would floor the rate at 0, even though SOFR will never be negative. And that one uses observation period shift, as we mentioned before. It's published on its value date. Next slide, please. Also, the Fed's publishing 30, 90, and 180-day compounded average SOFR values. They incorporate all the values, exactly those time periods prior, including weekends, and also published on their value date. Next slide, please. Okay, read our CLE code, LEG12. Say that again, that's LEG12. Okay. All right, so now what about the CMS rate? As everybody knows, LIBOR is an element of the CMS rate. And, nobody's talking about the CMS rate ceasing the way LIBOR, everybody's saying LIBOR is going away, but we're not talking about CMS in that way. So what do you do if you're doing a CMS note? Well, you should include a risk factor to the effect the floating rate leg, which is currently based on 3-month US dollar LIBOR, is going to cease, and it's really under the ISDA swap protocol, it's going to become a SOFR rate with an adjustment spread. And you should say in that risk factor that you can't predict the effect on this change of this change. Again, nobody's talking about CMS going away. We haven't seen a uniform approach on CMS fallbacks. Some people, because again, with all of these rates, you don't want to get caught up in what happened to LIBOR, where you keep repeating the last rate. So some people are adding a discretionary adjustment provision. You want to make sure that it's clear in your notes that when LIBOR goes away, it's going to switch over to a SOFR measure. So let me see. And then I think lastly, I think if you were an EU member issuer, perhaps you have in your EMTN program for CMS, the EU benchmark fallback provisions, you could go to those. Okay, next slide, please. So what do we do about these tens or more billions of dollars of LIBOR floating rate notes? So there's a number of potential solutions. None of them are perfect. First of all, are there going to be plaintiffs who can show damages due to their LIBOR notes defaulting into fixed rate notes for the remaining term to maturity at the last fixing? We don't know. And that may depend on where LIBOR stops. If it stops high, holders might be very happy. So a couple things going on. You could do an exchange offer. That would entail making an offer to holders of the outstanding legacy floaters to exchange those for new ones of equal principal amount with the same terms as the outstanding notes, except for the interest rate. The issue with anything like this is, again, if you don't get 100% participation, you could end up with twice as many QSIPs. You have the people who accepted the exchange, they're in the new note. Those who didn't accept, they're still in the old. So here, how this would be done is typically an issuer would rely on a private exchange offer affected to QIBs and institutional accredited investors in reliance on Section 4A2 under the Securities Act. They could do an exempt exchange offer using Section 3A9. One possibility is an issuer might want to try and clean up if they have a lot of series. They can maybe offer holders of multiple series to kind of exchange into one series. You wouldn't really know in advance, of course, how many people would participate, but what you could do before spending a lot of money as an issuer, you could go and identify the large holders. Might consider approaching large holders that are QIBs before launching a full exchange offer, engaging those QIBs in order to see are they willing to convert, possibly lock them up, so the issuer can announce their agreement to exchange in advance. Next slide, please. Consent solicitation, that's something, and I'm going to talk about that in depth in a couple more slides. There, you might only get 51% approval, and as a result, the issuer again might have a large group of holders left in the existing floating rate notes, and again, you might end up with 2 QSIPs. Now, a better approach might be to issue new SOFR floating rate notes and use the proceeds to undertake a cash tender offer for all your outstanding legacy LIBOR notes. Or an issuer could announce that from time to time it's going to consider open market privately negotiated purchases of the legacy notes. There'd be no specific time period, no specific offer to purchase at a set price. Every repurchase would be a one-off one, not conditioned on any other purchase. And this would kind of provide a signal to the market regarding the issuer's intention to buy back any floating rate notes. Next slide, please. Okay, so I guess talking about consent solicitations, this is an interesting area. There's a lot of practitioners who are talking about this. In our standard supplemental indenture provision we have here is, you know, if you want to essentially change the stated maturity of the principal or any installment or principal or interest on any security, or reduce the principal amount thereof or the rate of interest thereon, you need the consent of each consent of the holder of each outstanding security affected thereby. And the reason I'm reading this carefully is people have always looked at that and generally said, oh, you need the consent of 100% of the holders, but that's really not exactly what it says. It says the consent of the holder of each outstanding security affected thereby. So what does this mean? Now, there's an interesting interplay with Section 316B of the Trust Indenture Act of 1939, a very similar provision there where it says the right of a holder of any indenture security to receive payment of principal and interest on the respect or after the respective due dates for such, or to institute suit for the enforcement of any such payment on or after such respective dates shall not be impaired or affected without the consent of such holder. Now, you know, the question is there's no cases on point that discuss Section 316B of the Trust Indenture Act in the context of a consent solicitation to amend an interest rate calculation. Now, the question is what if you were to, you would kind of craft a consent solicitation where essentially holders who consented went out to them and said, look, we want to amend your LIBOR floating rate note to add in the ARRC fallback provisions. If you consent, you move into a new QSIP. If you don't consent, everything stays the same. You stay in the original QSIP. So in other words, at the end of the day, every holder would have consented to their interest rate. And what we're trying to do here is get to the ability of a law firm to give a clean opinion to the trustee. Well, we don't know the answer yet. That's something everybody's working on, but that's a big issue because if you could get to a consent solicitation, that would be very, very helpful for your legacy LIBOR floating rate notes. Next slide, please. Now, the other thing is the New York State legislative solution. Don't hold your breath. We don't know when this is going to pass. And frankly, I was just reading an article the day. They don't even have a sponsor. And the legislature is more concerned with COVID than anything. But the ARRC did put this in. The interesting thing is it's vulnerable to a challenge for being in violation of Section 316B of the TIA again. So the way this proposal would work is it would automatically, and by the way, this affects floating rate notes, loans, securitization. So now the only part with the TIA issue would be registered floating rate notes, not 382 bank notes, ones that are registered where an indenture's been qualified and T1's been filed with the SEC. So the way this would work, it would automatically replace US dollar LIBOR in a typical legacy LIBOR floater with SOFR. Whenever LIBOR was replaced, the fallback provisions will automatically trigger a replacement to the ARRC's, so the ARRC SOFR fallbacks, and you would disregard those polling provisions where, if something wasn't on the Reuters screen, the agent would go try and get quotes for deposits and loans from banks. Next slide, please. So the potential conflict with the TIA is, let's imagine you have a legacy LIBOR floating rate note holder and claims that it has suffered damages because the last LIBOR fixing was higher than the replacement SOFR rate, even with a spread adjustment. In other words, this holder wants to keep his note saying, I understood what this note said. I know what it says. If LIBOR goes away, I'm going to be stuck with the last LIBOR fixing. And it was nice and high, and that's my interest rate. And they would claim that the change in interest rate made by the proposal was an impermissible impairment under the TIA to the holder's right to receive interest, or that right was impermissibly affected without their consent. So now, if it ever got to that, and the statute came up for invalidation, hopefully in front of a judge, hopefully they would only invalidate with respect to registered notes. It could still be an answer for Rule 144A 382 LIBOR notes. Now that concludes my part. I'm going to read the CLE code one more time and then hand it over to Brendan. The CLE code is LEG 12. That's leg 12. Thank you.
Thanks, Brad. And before we move into, so I'm just going to talk about the U.S. federal income tax implications of replacing LIBOR. But Brad and I were talking the other day, just putting all of what he just said in the context of structured products. And we thought it might be helpful to go over a couple of the questions I asked him here on the call, if he doesn't mind. So one question is, Brad, are people in the structured products community amending notes retroactively to add LIBOR fallbacks to outstanding things, or is that not going on?
It's not. You can't amend. This is why the consent solicitation part is so important. You can't amend an existing note, and this is that the question is, can you do it with less than 100%? What about the TIA? These questions aren't really answerable right now, so nobody's going to go out and do it because you're not going to be able to give a clean opinion to the trustee. But interestingly enough, I just found out that Federal Farm Credits Bank Funding Corporation launched an exchange offer for 13 series of LIBOR notes, and they're going to replace them, try and exchange it from notes with the exact same terms, but using SOFR. So that's kind of interesting, because here's someone using they're not amending them, they're going for an exchange offer, and no sweetener offered or anything. So so it's interesting. So here's an issuer actually going out and trying to solve the problem.
But so for structured notes, you would kind of have to do it node by node almost, unless you're able to do some kind of sweeping broad replacement.
Yeah, well, I think structured notes, if they're registered, I mean, the only time I think you do it note by note is their Section 3A2 bank notes typically are not issued under an indenture, and they're under an exemption, so they're not subject to the Trust Indenture Act. And those notes, those holders could individually negotiate. The issuer could go out and individually negotiate with those holders, but any registered structured notes, you're going to run into this problem of whether you need 100% consent or not. So it's only going to be like under the 3A2 bank note programs, or maybe 144A notes, where the issuer can go out and negotiate an amendment with each holder individually.
And so that's kind of the historical side. And then in terms of what people are putting into like base documents for structured products now, is that almost straight ARRC replacement language, or is there variation?
I'd say pretty much people are doing ARRC. If they're not, they should be.
Got it. Got it. Excellent. Well, thank you for that. Some of that will become relevant to some of the pieces I'm about to talk about. So you see here on slide 76, we're going to be talking about the main U.S. federal income tax consideration for replacing, either adding LIBOR fallbacks to an existing instrument, or when LIBOR is ultimately replaced a little bit down the road. And so you may have come across this issue when you try to amend any terms of any existing instrument. Your tax lawyers might say, well, hold on, we got to think about that, as we often do. And that is because anytime you amend a term in an existing debt instrument that's already been issued, there is a potential for that amendment to be a significant modification, which is kind of a defined term for US tax purposes. And if it is, then you could have a deemed exchange, which could be taxable to US holders. And it could have some other implications, such as creating OID on the note, depending on the fair market value of the note at the time of the deemed exchange. Could be cancellation of indebtedness, income to the issuer, and and negative consequences like that. And the rules in this space are in the debt area. There's a bunch of regulations for amending debt instruments, and there's no similar set of rules for non-debt instruments like many structured notes. But people kind of look to because there is no guidance and there's a nice set of rules for debt, people look to the debt rules for non-debt instruments as well. So as you can imagine, this is a big problem with a lot of notes outstanding, not just structured products, in all industries. And so people have been asking for a solution from the IRS to LIBOR replacement, both adding fallbacks and ultimately acting on a fallback at the end of 2021. There are kind of three pieces of guidance. One is existing guidance, which I'll touch on a little bit. Two is a set of proposed regulations. And the interesting thing about that is those regulations actually came out. I think I had a panel at 10 a.m. for the Structured Products Association last year, and it came out like 45 minutes before I presented. So I didn't have time to digest them and present on them. And I might have mentioned I'll cover them this year. And so if you've been on the edge of your seat, I am going to do that. So that's a set of proposed regulations came out last year. And then actually fresh off the government presses is a revenue procedure that came out at the end of last Friday, that applies when you are amending an existing instrument to add specifically ARRC or ISDA fallbacks, which, as Brad mentioned, in the structured products context, it may not be that relevant because people aren't really amending things at the moment, but they might later. So we'll go into that. Plus, it's fresh news is always great. So let's start with what the existing rules. These have been around for a while, maybe 10 or more years. And there's kind of two ways that your amendment of a terms is not going to be a deemed exchange, like I described. And so there's two exceptions. One is if the amendment is a unilateral option of the issuer or the holder, if the holder option is kind of subject to some additional restraints. If it's an issuer option, it's got to be completely unilateral. So it can't have any holder consent or anything like that. And as Brad just described, that's not super useful because generally for the registered deals, it's going to be that the holders would have to consent to amendment of the terms. And then, yeah, so that's the unilateral option exception, and then related is the option exception, and then related is the option exception for holders, not that important. And then the final exception under existing rules is a change that is pursuant to the terms of the instrument. And so here, this could be useful because if you put ARRC fallbacks, as Brad kind of went over, when LIBOR ultimately goes away, you're going to fall back to probably term SOFR or compounded SOFR. So there's probably an argument there that it's pursuant to the terms, but some of the later steps, the adjustment is maybe not so clear. And some of the later steps in the waterfall, the issuer just comes up with a rate if nothing else is available. And that would not be, arguably not strictly pursuant to the terms because the terms don't specify which rate. So that's kind of existing rules. But now let's talk about the special rules just for LIBOR replacement that have come out. So if we go to the next slide. Like I said, these came out in October of 2019, almost exactly 1 year ago. And they kind of address three situations. The first is replacing a LIBOR rate with a qualified rate, which we'll get into in a minute. So that's the actual replacement. Adding a fallback to an existing instrument, that's number two. And then the third one is a little bit inception-y, but it's if LIBOR is actually the fallback for a different rate on your instrument and you replace or you add a fallback for LIBOR when it's acting as a fallback. I know it's confusing, and that's really not the big situation, so don't stare at it too hard on that one. And so basically, if a modification meets the proposed regulations, then it's not going to be treated as a modification under the tax rules, and therefore it won't be a significant modification, and there won't be any of these potential negative tax implications that I kind of started with. So if we go to the next slide. So if you want to fall within these proposed regulations, there's basically two requirements. One of them is pretty broad and pretty open, and the other one has some complications that we'll discuss. So there's basically two requirements. One, it's got to be one of the specifically enumerated rates. And then two, the fair market value of your instrument before the modification has to be substantially equivalent to the fair market value of the instrument after the modification. So we'll start with the first requirement, and that is it's got to be one of the enumerated rates. Here you'll see some of the celebrity rates that you'll see SOFR, the ARRC's favorite, SONIA, which for English type instruments is the more popular, and among a number of other rates that are specifically enumerated. But the key from a US tax perspective is this third bullet I have here, any qualified floating rate under the Treasury regulations. And these are the regulations for variable rate debt instruments, which you might come into if you do fixed floaters, for example. But basically, a qualified floating rate generally is any rate that's meant to contemporaneously measure the cost of borrowed funds. So that's going to be almost anything that replaces LIBOR, you would think. So this first requirement that it has to be an enumerated rate is pretty easy to meet, and it's pretty smooth sailing. If we go to the next slide. So this is the trickier one where there's some thorns with the proposed regulations that we'll touch on, and that is the fair market value. It's the substantial equivalence test, they call it. And the fair market value of the instrument before the modification needs to be substantially equivalent to the fair market value after. And that doesn't sound, keep in mind what we're trying to do is we're trying to put some terms in an instrument that's issued today so that when LIBOR is ultimately replaced, we don't have to worry about it. And the way this is structured, the definition of this, it's not entirely clear what you could build into an instrument today that would for sure satisfy this requirement. So if they have a broader like catch-all that just says the exact words in that first bullet that the two are substantially equivalent. What does that mean? They have two safe harbors you can use. One is the historic average safe harbor, and then the second is the arm's length safe harbor. So we'll get into those and kind of their imperfections. But one thing to keep in mind is that if there's any one-time payment or anything made in association with the modification to the LIBOR fallback, then that's taken into account for whether or not the two are substantially equivalent. So the first safe harbor, the historic average safe harbor, and that is if the replacement rate does not differ by more than 25 bips from the LIBOR rate that it's replacing, you fall within the historic safe harbor, and that's taking into account the spread, et cetera. But as I said, at the moment, we're trying to build in mechanics to an instrument that would allow the replacement of LIBOR at the end of 2021 to meet this test. And it's not entirely clear that it'll be within 25 bips, or at least you can't predict that at the time you sign an instrument, say today. And I know this is kind of old news now, but there was one day last year, I can't remember, maybe Brad remembers, in the summer where SOFR went like through the roof up to like 8% or something like that, and then immediately back down around where LIBOR was. And it kind of freaked everyone out a little bit. I mean, that's kind of, I don't think that's happened since, but it's an example of something that could happen that could potentially bring it outside of the 25 bips. So that's one potential safe harbor for the substantial equivalence test. As I said, not great for the reasons you can see. If we go to the next slide. So here's the second option, and that is the arm's length safe harbor. And here, the parties to the instrument cannot be related, and then the parties have to determine, based on arm's length negotiations between them, that the fair market value of the instrument is substantially the same before and after. And so there's some troubles with this. One, it's not clear. It kind of just leaves it at the parties. And as Brad mentioned, it might be the trustee that's involved on behalf of the holders, not the holders themselves. And so it's not clear who are the parties. Is the trustee allowed to negotiate with the issuer on behalf of the holders? It doesn't make that clear. Another point is, how do people, this is the one we have on the slide, how do people substantiate their determination of substantial equivalence? Is it like an email? A third problem with it is that, again, I know I keep emphasizing this, but we're trying to put in something that we can rely on at the end of 2021 today. And it's not clear from the proposed regulations that you're permitted to agree kind of upfront that the two rates are meant to be substantially equivalent. So if we go to the next slide, you'll see the IRS, so they came out with these in October, and then they just basically got pelted with comment letters about the proposed regulations, pointing out some of the flaws I just mentioned, along with, or maybe not flaws, but imperfections I just mentioned, and along with more that I didn't discuss. And those comment letters came, I know that we at Mayor Brown worked with the Structured Finance Association to put one together. The ARRC itself sent a couple, I think. The New York State Bar Association sent some, and the list goes on. And we have heard that the IRS, someone speaking at a panel, a representative of the IRS said that they are considering them for what that's worth. And so hopefully the final version of those regulations, not sure when that's going to come out, but hopefully when that does come out, it'll be a little bit broader. So that's the proposed regulations. If we go to the next slide, this creates a lot of excitement in my life when something new comes out in an area I'm focused on, and that is Revenue Procedure 2020-44. And that came out just at the end of Friday. So this is brand new news. It's on a separate track from the proposed regulations. It just only mentions the proposed regulations and that they're working on finalizing them, but they wanted to get this separate advice out in the interim. And so this advice, the one key thing to keep in mind up front is that the revenue procedure only applies to amending legacy instruments that don't have a fallback to add one. So this is not something that you can rely on at the end of 2021 when you're looking prospectively and ultimately, exercising a fallback. So it's also limited a little bit further, or the main limitation is that it is basically a blessing only for ARRC recommended fallbacks and ISDA recommended fallbacks. The ARRC fallbacks, it's kind of by structure. So Brad went over the floating rate note structure. Each industry kind of has its own. I think at this point there might be 10, perhaps 11 different structures that they have recommended language for. And they enumerate that in the notice, which specific contract language they're referring to. And then the ISDA, I think their language, they've published it, but it doesn't become officially published till the 23rd or something like that. But their model language is out there. And so basically what the revenue procedure asks you to do is copy and paste those terms, the model terms that they come up with, into your instrument with very little deviation. And if you do that, then you're not going to have a significant modification and any of those negative implications that I described. So that's one of the reasons why I asked Brad, when you're putting LIBOR fallbacks into structured notes, is that something that you generally just bring over the ARRC concepts almost completely? The answer is yes. I think in the floating rate note space, the answer is yes. It's not yes in all spaces. And so if you are going to deviate from the ARRC language, they only have a few permitted deviations. They have a couple just for like changing the names and stuff like that. That's not a big deal, and you would expect that not to take you out of the guidance. But then the most flexible one they have is I put the language here on the slide in quotes because it's the most flexibility provided other than a strict cut and paste, and that is deviations from the ARRC language to add, revise, or remove technical, administrative, or operational terms, provided that it's necessary to implement the ARRC fallback. So they list a few examples of that. That is the changes to interest period, the timing and the frequency of determining rates, and the timing and frequency of making payments of interest. So you can see it's not super broad. Like if you wanted to tinker with the trigger mechanics for when LIBOR is actually going to be replaced, it seems that might not fall in here, and that might not strictly enough follow close to the ARRC recommended guidance. And so that's the kind of the three worlds we have right now on the US tax side. Hopefully those proposed regulations, when they're finalized, are going to be a little bit more broad. But until then, that's kind of the world we have for replacing LIBOR. And
Thanks.
so, yeah.
Thanks, Brandon. We'll just pause for a minute and see if there are any audience questions for Brennan or for Brad. Okay, well, thank you both. Really appreciate it.
Welcome.
Thanks.